Hi, I'm Lori Hauptman, and I'm here today with my husband, Yale. And we're here today to talk about some common questions that our clients have about wills. Hi, Yale.
Hi, Lori.
So, initially, I think most people want to ask, why do I need a will?
Okay, well, a will, as you know, Lori, is an opportunity to pass your assets to your loved one, to take care of your loved one, and to do it in a tax-efficient manner. The law says that you can impart some instructions, but you have to do it in the proper manner as set forth in the particular laws that apply to the execution of wills.
Okay. So, why should I consult with an attorney? Many people know that you can buy wills online or get it at a Staples.
Or do it yourself. Well, you can do it yourself. It's what's called a holographic will. But if you do, you run the risk that you're not familiar with the specific requirements that satisfy a proper will, because if the technical aspects of the execution are not right, what you end up doing is you are not preparing a valid will, and after I die, it's too late.
Do I even need a will if I hold all my assets jointly with a spouse or a loved one?
Good question. One we see very often. There's actually three classes of property, is what we tell folks. Only one automatically passes by through the will. Jointly held property, which is property that is joint with right of survivorship, is property that passes by operation of law. Second type of property is contract property. You would find that would be anything that has a designation, a beneficiary designation on it. Could be retirement accounts, IRAs, 401ks, could be life insurance. You pay the premium to the life insurance company, you fill out a beneficiary form. And then the third class of property is everything that's not in the first two, and that's what automatically passes by the will. But if you don't have a will and you don't take advantage of some of the opportunities to save on taxes, for example, you're not going to be able to do that with a jointly held account. The other reason is people a lot of times have joint accounts for convenience while they're alive. My daughter lives nearby. It's not that I don't love my son equally, who lives out in California, but I put my daughter's name on my account just in case I need her to access it. Well, what that means, and people don't realize it, is that everything in that account passes to the daughter when I die, and that probably, or may not have been my intention. I just didn't think about it.
So, what does it mean to probate a will? We hear that expression a lot.
We do, and we get calls from families. You know, mom or dad passed away. I need to probate the will, right? And the answer is you only need to probate the will if there is some asset or some reason that you need to do something on behalf of the deceased person. Probate means to prove, and very simply, New Jersey is a probate-friendly state. The will is, original will is submitted. The surrogate, which is the elected official that oversees probate in New Jersey, doesn't take a look at the contents of the will, but looks to see whether it's properly executed, which goes back to why you probably don't want to do a will yourself. And if everything appears to be in order, admits the will to probate, appoints the executor, and that person now gets a piece of paper from the surrogate with an official stamp on it or seal, and is now able to present that to any third person or third party. So if I say I'm the official representative of the estate of John Doe, and you show up at the bank and say the same thing, well, how's the bank know it's me and not you? It's that piece of paper from the surrogate.
So what happens, since we were just talking about having a will, to my assets if I die without a will?
Okay. If you die without a will, every state has a set of laws that establishes how property is going to be distributed. Those are what are called the intestacy laws. And the intestacy laws basically are the state has decided how your assets are going to be distributed. So you've lost the opportunity to decide that for yourself, and you've lost any ability to take advantage of tax planning strategies. And in most instances, the assets are going to pass to spouse, children, and then beyond that, more distant relatives.
Yeah, we live in a very mobile society. People move from one state to another. If they draft a will in one state but then end up in another state, how do they handle that?
Common question we get, and I will say, and the answer is I'm presuming that this will apply for all 50 states, but obviously we don't know the laws of each of the states. But if a will is properly executed in one state, it should be valid in another state. However, it still is a good reason, or a good idea, I should say, to, when you move to a new state, to check with an experienced attorney in that state, because the laws of that state may dictate that the plan that was put into place here in New Jersey may need to be modified given the laws of that other state.
Okay. So thank you for listening. I hope we answered some of your questions. If you have any more questions that you want answered or want some more information, please call Hauptman & Hauptman at 973-994-2287 or check out our website at www.hauptmanlaw.com.